2 out of 6 jurors couldn't make a decision. They couldn't decide whether to give a verdict for the patient or for the doctor. How many jurors do you actually need in order to reach a verdict here in New York in a medical malpractice case? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It's a beautiful but crisp day today here in Great Neck, and I wanted to share this great information with you. So now here's the scenario. You brought a lawsuit against your doctor claiming that he was careless and violated the basic standards of medical care, causing you significant harm and injury. The doctor in response says, "Why did you sue me? I did nothing wrong. And even if I did something wrong, so did you, patient. You didn't listen to me." And now he says, hey, if I did something wrong, whatever I did didn't really cause or contribute to any injury you have. And then he argues, you know what? Your injuries really are not as bad as you claim them to be. Those are the typical defenses that we see in medical malpractice cases. So now the defense refuses to negotiate. They are fighting you tooth and nail throughout the entire course of your litigation. Everything is a fight, every single thing. You say it's day, they say it's night. You say it's morning, they say it's afternoon. Whatever you're arguing, they say just the opposite, which is crazy. So now it takes 2 years for your litigation to get to trial. You're now at trial, and now it takes you 2.5 weeks to put on all of the evidence and all of the testimony. Finally, your case has come to an end. The judge turns to the jury and says, "Ladies and gentlemen, we've now reached the point of the case where you have heard all the testimony and all the evidence. In just a few moments, you're going to go back into the jury room to begin deliberating, to decide whether the injured patient is more likely right than wrong, that what she is claiming is true. That will be up to you to decide, because you, the jury, are the fact finders. I, the judge, will be giving you the law, and you will then take the law and apply it to the facts." Now, you should know something, and it might be eye-opening for you. When the jury is asked to reach a verdict, they don't simply answer one question and to say, okay, we give a verdict for the patient or we give a verdict for the doctor. That's not how it works. That's not how any of it works. Instead, the jury verdict is comprised of a series of questions. The jury has to answer each and every question individually. But now, how many of these jurors actually have to answer these questions? Well, here's something else that you might not know. In a civil lawsuit in New York involving a medical malpractice matter, there are 6 members of the community who sit in judgment on this type of case. So now where you have a jury trial, you have 6 members of the community who were chosen at the very beginning of the case, chosen by the 2 lawyers involved in the case, and now they've been sitting and listening to all the testimony throughout the entire 2 or 3 weeks. And now it's time for them to go ahead and make a decision. But you should know that not all of those 6 jurors have to agree on each and every one of the questions that they are being asked. So now the question becomes, okay, well, if there are only 5 jurors who agree, can you get a verdict in your favor? The answer is yes, you can. Well, what if there are only 4 jurors who reach agreement and 2 disagree? Can you reach an agreement? Can you reach a verdict? The answer is no, you can't. If there are only 4 jurors who decide in agreement together to vote one way, let's say for the patient, that's not a verdict. You cannot reach a decision just with 4 jurors. You need 5. You must have 5 in New York, 5 out of 6. If you have 3, you can't reach a verdict. If you have 2, you can't reach a verdict. Or 1, you must have at least 5. Now, here's an interesting point. So now the very first question that the jury will have to answer is, was the doctor careless? In legal terms, it's going to be written down on a piece of paper that says, was the defendant negligent? And all that really means is, was the doctor professionally careless? Did he violate the basic standards of medical care? Yes or no? If the answer is no, then your case is over and finished, and you get sent out of court without a dime, nothing. If, however, the answer is yes, now the jury then has to go to the second question. And the second question typically is, okay, now that you've decided that the doctor was careless, was his carelessness a cause of your injury? It does not have to be the cause, it only has to be a cause, singular, not plural. It only has to be a cause because there could be multiple causes for your injuries. If the jury says, yes, there is that link, that bridge between the wrongdoing and your injury, guess what? Now they will then go to the next question, which involves a series of sub-questions about how much money you are to receive as a result of all the injuries and losses and harms that you incurred because of your doctor's carelessness. So now let me get back to the original title of this video. If there are 2 jurors who disagree and say, no, I don't agree, I don't think that the doctor was careless, guess what? Now they can't even answer the first question. And the judge tells the jury, listen, you are to discuss your thoughts and opinions amongst yourselves and ultimately reach a consensus as to who is entitled to a verdict in their favor. And now, if two of the jurors disagree and they do not believe that the doctor was careless, now you've got four jurors who say, yes, he was. Now you've got a problem. So now, two of them have to try and convince each other. The jury collectively has to try and decide, okay, let me explain why I believe the doctor's careless, and now somebody else is going to turn around and say, no, let me explain why I believe this doctor was not careless. Okay, so now they go on to the second question, and that is what we call proximate cause. Was the doctor's carelessness a cause of your injury? And now, they've got the same exact problem, except this time, two different jurors say, no, there's no connection between the wrongdoing and the carelessness. And now you have four different jurors who say, yes, there is a connection. And so now one of the jurors finally gets convinced, and now he says, okay, I agree with the four of you. Now we have five jurors who say, yes, there is a connection between the wrongdoing and the bird that's tweeting above, which is wonderful. I love hearing that, but it's lovely because it's interrupting what I'm trying to say. Thank you so much. Okay, so now in this scenario, we have one juror who still disagrees, five jurors who agree that there is a link between the wrongdoing and your injury. So what if those five jurors on the second question are different than the jurors on the first question? The answer is you can still go forward. They do not have to be the same. As long as you have a total of 5 jurors out of 6, you then can go ahead and answer that particular question. So why do I share this great information with you? I share it with you just to give you an inside look at what goes on in these civil lawsuits involving medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter happened here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because the birds are tweeting on this beautiful day, no, I'm serious. If you do have questions and your matter did happen here in New York, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.